Swayam Prabha. Digital India. Educated India.
Good morning, students. My name is Shalini Sharma. I am child right professional having 5 years experience as chairperson Child Welfare Committee and in my present role of 1.5 year experience as member Juvenile Justice Board. Today, I am going to start a course on Juvenile Justice, Care and Protection of Children Act 2015. This course is designed for undergraduate and postgraduate children, and in this module of lecture number 1, we will study History of Juvenile Justice Act, who is a child in need of care and protection, and who is a child in conflict with law. And we will also deliberate on principles of Juvenile Justice Act. Children are nation's supreme asset. India has enacted Juvenile Justice Act in furtherance of our constitutional and international obligations. The Juvenile Justice, Care and Protection of Children Act 2015 is a comprehensive law that replaced the earlier Juvenile Justice Act of 2000. The Act provides for the care, protection and treatment of children who are in need of care and protection or who are in the conflict with the law. It also deals with the adoption of children, their rehabilitation and social reintegration. The Act sets up juvenile justice boards and child welfare committees at the district, city and block levels to handle cases related to children. It also outlines the procedures for dealing with the children in conflict with the law, including their trial, sentencing and punishment. The Act recognizes the principle of restorative justice and promotes rehabilitation and reintegration of children in conflict with the law into the society. So, dear students, let us see the evolution of Juvenile Justice Act 2015. To understand the Indian architecture of the Juvenile Justice Act, it is important to first understand its evolution from British legal regime, where the foundation of these laws first laid and later travelled to India. British India, as our country was called then, also received similar laws from 1850 onwards. Around the year 1795 onwards, the culture of ragged schools was very popular in Europe, UK for lodging homeless children. But over the time, the condition of these schools became pathetic, neglected and stigmatized because of association of children of these schools with delinquency. These ragged schools caught the attention of the famous author Charles Dickens, who started visiting these schools and wrote many of his short stories and novels about the apathy of the children staying in these schools. One of his famous literary work, Oliver Twist, which put forth a brutal and heart-wrenching picture on the treatment of the orphans staying in London. The elite of the London went into denial after reading the heart-wrenching story of the Oliver Twist. They did not accomplish the elite society like them can treat their children like this. Moral awakening of the English elite and thinking class coupled with the support by Charles Dickens and several others led to the enactment of special laws like Apprentice Act and Reformatory School Act. This is the first time when the thinking of people started developing towards that the children commit crime because of their socio-economic conditions, and what is better for them, either punishment or reformation. The Apprentice Act of 1850 was the first piece of legislation dealing with the children in conflict with the law. The Act allowed courts to treat children who had committed petty offences as apprentices instead of sending them to prison. The word apprentice, as we all know, is to stay with somebody and to learn life skills. After some change, the Reformatory School Act was also introduced. It is also a radical piece of legislation and provided that children under 15 years of age who were sentenced to imprisonment may be sent to reformatory schools instead of prisons. British India, as our country was called then, also received similar laws from 1850 onwards. In India, prison reform movements was also going on during that time, which led to the formation of the first Indian Jail Committee, which gave its recommendation in 1918 and 1920. Few of its recommendations were: child offenders should not be lodged in the same jails as adult prisoners, and thus we have observation homes now. There should be separate courts to try the cases of children, and we have juvenile justice boards now. To have child-friendly procedures or procedures different from adults, and thus we have Juvenile Justice Act now. And India became independent, and we had our own first Model Children Act 1960, which was enacted and only applied in Delhi. But subsequently, various other states enacted their own state children acts based on this Model Children Act 1960. Model Children Act 1960 provided for two separate adjudicatory bodies to deal with children in conflict with the law and children in need of care and protection. It prohibited the imposition of death penalty or sentence of imprisonment on children and the detaining of children in jails or police stations. In the year 1985, India became signatory to United Nations Standard Minimum Rules for the Administration of Juvenile Justice 1985, the Beijing Rules, which led to the enactment of the first centrally applicable Juvenile Justice Act in India, Juvenile Justice Act 1986. So, dear students, from state subject to Juvenile Justice Act becoming a central subject at this stage. Indian government ratified the UN Convention on the Rights of Child 1989 in 1992. And keeping with the global momentum of securing child rights and moving away from retribution to restorative justice, it enacted the Juvenile Justice Care and Protection of Children Act 2000. The word justice was clarified in the title only. For children, it means care and protection. The 2000 Act was implemented with full force, but around the year 2006, the limitations of this Act started coming into force. And the preparation of amending JJ Act started, as the government wanted to cure several deficiencies in the Act of 2000 and wanted to make a more workable, pragmatic and effective law. Delhi gang rape case, Mumbai Shakti Mill case, and a huge media and public engagement with the subject of crime by children altered the tone of care and protection of earlier acts and resulted into enactment of Juvenile Justice Care and Protection of Children Act 2015 in its present form, which has made a historic departure from its rehabilitative tone to reformative track. So, dear students, let us look at the timeline of this act. The first act which we had since independence was the Children Act of 1960, the Juvenile Justice Act of 1986, the Juvenile Justice Care and Protection of Children Act of 2000, the Juvenile Justice Care and Protection of Children Act of 2015, more commonly known as JJ Act 2015. The Juvenile Justice Care and Protection of Children Amendment Act 2021 and the Juvenile Justice Care and Protection of Children Model Rules 2016 as amended in 2022. The Juvenile Justice Act came into effect on 15 January 2016. When this act came into force, it applied to whole of India except the state of Jammu and Kashmir. But after the abrogation of Article 370, it is applied in the UT of J&K, Ladakh also. Juvenile Justice Act is a primary legislation for children in need of care and protection and children alleged to be found in conflict with the law. It mandates a child-friendly approach in the adjudication and disposal of matters in the best interest of the children. It mandates a safety net for the vulnerable children by way of institutional and non-institutional mechanism. Before going deep into this law, we need to understand the definition of a child. According to this act, child is a person who has not completed 18 years of age, and this act classifies the term child into two categories, namely child in conflict with the law CCL and child in need of care and protection CNCP. So dear students, let us deliberate on who is a child in need of care and protection as defined in section 2 subclause 14 of the JJ Act 2015. So, child in need of care and protection means a child who is found without any home or settled place of abode and without any ostensible means of subsistence, or who is found working in contravention of labour laws for the time being in force, or is found begging or living on the street, or who resides with a person, whether a guardian of the child or not, and such person has injured, exploited, abused or neglected the child, or has violated any other law for the time being in force meant for the protection of child, or has threatened to kill, injure, exploit or abuse the child, and there is a reasonable likelihood of the threat being carried out, or has killed, abused, neglected or exploited some other child or children, and there is a reasonable likelihood of the child in question being killed, abused, exploited or neglected by that person, who is mentally ill or mentally or physically challenged, or suffering from terminal or incurable disease, having no one to support or look after, or having parents or guardians unfit to take care, if found so by the board or the committee, or who has a parent or guardian and such parent or guardian is found to be unfit or incapacitated by the committee or the board to care for and protect the safety and well-being of the child, or who does not have parents and no one is willing to take care of whose parents have abandoned or surrendered him, or who is a missing or runaway child, or whose parents cannot be found after making reasonable inquiry in such manner as may be prescribed, who has been being or is likely to be abused, tortured or exploited for the purpose of sexual abuse or illegal acts, or who is found vulnerable and is likely to be inducted into drug abuse or trafficking, or who is being or is likely to be abused for unconscionable gains, or who is the victim of or affected by any armed conflict, civil unrest or natural calamity, or who is at the imminent risk of marriage before attaining the age of marriage and whose parents, family members, guardian and any other person are likely to be responsible for solemnization of such marriage. So, we have seen that section 2 subclause 14, who are the children in need of care and protection are self-explanatory. The Act defines a large number of children who need the state intervention when it comes to their care and protection. Now, let us see who is a child in conflict with the law. As defined in section 2, subclause 13, CCL is a child who is alleged or found to have committed an offence and has not completed 18 years of age on the date of commission of such offence. Offences committed by child below 18 years are categorized as 1. Heinous offences. Section 2, subclause 33 defines heinous offences as the offences for which the minimum punishment under the Indian Penal Code or any other law for the time being in force is imprisonment for 7 years or more. Heinous offences like death, rape, murder. Serious offences includes the offences for which the minimum punishment under the Indian Penal Code or any other law for the time being in force is more than 3 years and not exceeding 7 years, like stealing. Now, let us see what are petty offences. Section 2, subclause 45 includes the offences for which the maximum punishment under the Indian Penal Code or any other law for the time being in force is imprisonment up to 3 years. Juvenile Justice Act 2015 introduced a new concept of preliminary assessment where minors aged between 16 to 18 years who are accused of committing heinous offences can be tried as adults after the culmination of preliminary assessment test. Under section 18, subclause 3, after preliminary assessment, board may order transfer of the child who is between 15 to 16 years of age as an adult, and then board may order transfer of the trial of the case to the children's court. Every child in conflict with the law is a child in need of care and protection because the child has fallen out of the safety net of the society. We should not forget the child in conflict with the law is also a child in difficult circumstances and has been robbed of an opportunity of safe and secure childhood. Dear students, now let us see what the important principles of the Juvenile Justice Act says. Juvenile Justice Act is a landmark act and provides for care and protection for children both in conflict with the law and children in need of care and protection. To administer this act in its real spirit, we need to understand and follow all the 16 principles mentioned in this act. Principles of juvenile justice are like a guiding light, and whenever practitioners, members of CWCs, JJBs and courts find it any difficulty or ambiguity in interpretation of this act, they turn to the principles of this act, which the lawmakers have enshrined in the part 3 of this act. So, section 3 of the Juvenile Justice Act 2015 defines the general principles of care and protection of children to be followed in the administration of this act. Let us see what the section 3 says. The central government, the state governments, the board, the committee and the other agencies, as the case may be, while implementing the provisions of this act, shall be guided by the following fundamental principles, namely, first, principle of presumption of innocence. Any child shall be presumed to be an innocent of any malefied or criminal intent up to the age of 18 years. So, this principle says even if a child has committed an offence, he shall not be considered guilty. The child cannot have a criminal intent or a malified intention or a mens rea for committing a crime. So, the presumption is that the child is free from any criminal intent, even though the trial can begin about the child, but this trial is for the justice, and the justice term has been defined only in the definition of this act, that is care and protection. This is not for the punishment of the child, it is for his or her reformation. So, let us see principle, let us take the second principle, principle of dignity of worth. All human beings shall be treated with equal dignity and worth. Just because a case of a child is in our front, we should not take that case lightly. Whatever all human rights are enshrined, we should provide that rights to the child, and also the constitutional guaranteed child rights should also be provided to that child. He should be made to sit, he should be made to comfortable. The purpose of this act is to ensure the rights of the child, and his dignity and his worth should be restored at all points. Third principle is principle of participation. Every child shall have a right to be heard and to participate in all processes and decisions affecting his interest, and the child's view shall be taken into consideration with due regard to the age and maturity of the child. So, this principle of participation is a very important principle. Just because that child does not wish to participate or he does not have money to hire an advocate, we cannot give away with this important right of participation of the child. The board or the court or the committee, as the case may be, ensure that the child gets a fair chance to speak, gets to vent out his feelings, gets a chance to express what he feels like. In many of the cases where a child is in trauma and does not want to restore back to the families, the wishes of the child should be respected, and the restoration should be done only after the counseling of the child. Now, let us see the fourth principle, principle of best interest. All decisions regarding the child shall be based on the primary consideration that they are in the best interest of the child and to help the child to develop fully. So, students, we should not forget the spirit of the Juvenile Justice Act, which is for the reformation, rehabilitation and reintegration back into the society. So, when we are looking or dealing with the children, we should consider their best interest. We should not look as if we have to punish them, to correct them. The purpose should be to give them love and to bring them back to the society. The next principle is principle of family responsibility, which says the primary responsibility of care, nurture and protection of the child shall be that of the biological family or adoptive or foster parents, as the case may be. So, dear friends, it is the duty of every parents or every family to love, nurture and care and protect their children. But certain cases, some children are not so lucky, they fall out of the net of the society, and that is where the society, the government comes into play. And for the care, nurture and protection of these children, the Juvenile Justice Act aims for the opening of child care institutions and also for their upkeep and their bringing up of those children in those homes. Next, principle of safety. All measures shall be taken to ensure that the child is safe and is not subjected to any harm, abuse or maltreatment while in contact with the care and protection system and thereafter. So, children, this principle is of great importance. The whole aim of the juvenile justice system is to take care and protect the children who come into contact with this law. So, this law aims that right from the start of this act, when this child enters into this juvenile justice system, he is taken care of. As in the case of a child in conflict with the law, right from his apprehension to the final disposal of his case, all his child rights are protected, he stays safe, he is protected from the society, his identity is not disclosed outside. So, the main aim of this object is to protect the safety of the child. Positive measures. All resources are to be mobilized, including those of family and community, for promoting the well-being, facilitating development of identity and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this act. So, this principle says that whatever the resources community has, society has and government has, they should be mobilized for the best interest of the child. In certain cases, we come up across with the families who wanted to give away their child because they are very poor or they cannot keep their child in a safe custody. They come up to surrender their children. But in those cases, the government should provide for the social security schemes. The best interest of the child is with the family, and every measure should be taken by the government to ensure that child stays safe with his family. Principle of non-stigmatizing semantics. Adversarial or accusatory words are not to be used in the process pertaining to a child. So, dear students, this is also a very important principle. When we talk about juvenile justice system, the use of words is very important. As we use child in conflict with the law, with the child who has done something wrong, because when we say child in conflict with the law, it is for everybody to remember that he is a child first and in conflict with the law later. There are other also important words which are to be remembered, like the child is not arrested under this law. The child is apprehended. There is no trial of the child. There is only inquiry of the child. So, words do matter. To restore the child's dignity and worth, we should not call him by names and wrong words. Now, let's see the ninth principle, principle of non-waiver of rights. This is also a very important principle. Let's see what it says. No waiver of any of the right of the child is permissible or valid, whether sought by the child or person acting on behalf of the child, or a board or a committee, and any non-exercise of a fundamental right shall not amount to a waiver. Now, let's see. There is a victim, POCSO victim, and she has expired, and some of the media and journalist houses publish her photographs in the newspapers or in the news channels. Now, we can say that the child is dead. She cannot exercise her right, but let's see what this principle says. This principle says non-waiver of rights. Even if the child is dead, even if the child is not in a position to exercise his or her rights, still you cannot waive off the child's right. In other case, a child in conflict with law is present before the Juvenile Justice Board, and he is not in a position to hire a legal advocate for himself. And he also expresses that he does not want to engage with a lawyer. So, here the duty of the Juvenile Justice Board is that they should engage a free legal counsel for the child, because even if a child wants, even if the parents or the guardians of the child wants, nobody can waive off the rights of the child. Now, let's see the 10th principle, principle of equality and non-discrimination, which says there shall be no discrimination against a child on any grounds including sex, caste, ethnicity, place of birth, disability, and equality of access, opportunity, and treatment shall be provided to every child. This principle says that no child shall be discriminated on the grounds of sex, caste, ethnicity, place of birth, disability. for example, let us say there is a special able child who needs an institutional care and there is no such institution in the district. The state government cannot shy away from providing a new institution for that such child. Next principle है principle of right to privacy and confidentiality, which says every child shall have a right to protection of his privacy and confidentiality by all means and throughout the judicial process. This principle is very important, which says that the right to privacy and confidentiality of a child shall be protected, be it a child in need of care and protection or be it in a child in conflict with law. In many cases, we have seen where a child comes into conflict with the law, his identity, his particular details are shared with the media or journalist houses. No police officer, no other stakeholder can commit such an offence. This is a punishable offence under Juvenile Justice Act. The next important principle is principle of institutionalization as a measure of last resort, which says a child shall be placed in institutional care as a step of last resort after making a reasonable inquiry. The Juvenile Justice Act emphasizes on the emotional needs of the children, and it says if a child has to be put or sent into an institution, it should be as a measure of last resort, which means every attempt to rehabilitate, to reintegrate the child back with his family or to his community should be the first priority of all the stakeholders in this act. Let us try to understand this with an example. For example, a child is found abandoned at a railway station and he speaks a language which is not native of that railway station jurisdiction. The authorities of child protection mechanism must ensure that child is kept safe and restored back to his native place at the earliest. Now the 13th principle, principle of repatriation and restoration. Every child in the juvenile justice system shall have the right to be reunited with his family at the earliest and to be restored to the same socio-economic and cultural status that he was in before coming under the purview of this act, unless such restoration and repatriation is not in the best interest. So, this principle says that every stakeholder in this act should make the first attempt to reintegrate and repatriate the child at the very earliest to his home state or his native town at the earliest. Principle of fresh start. Now, this is the landmark principle of the Juvenile Justice Act. It says all past records of any child under the juvenile justice system should be erased except in special circumstances. So, by this principle we mean that if any child who comes into the contact of the juvenile justice system right from the trial to the conviction, his records shall be erased or removed from the JJB in special circumstances. If the case of the child is transferred to the children court, then that such record shall be transferred to the children court. The Juvenile Justice Act believes principle of fresh start with no baggage. That means if a child has come into contact with the JJ system, he is free to pursue his career ahead without any disqualification of being his conviction or his arrest as the case may be. Next principle, principle of diversion. Measures for dealing with children in conflict with law without resorting to judicial proceedings shall be promoted unless it is in the best interest of the child or the society as a whole. So, this principle says the minimum efforts should be made to keep the child away from the judiciary system, and if there is a need for a child to come in the purview of the JJ system, then only the Juvenile Justice Board should keep the inquiry of that child with itself. The next principle, principle of natural justice, which says basic procedural standards of fairness shall be adhered to, including the right to a fair hearing, rule against bias, and the right to review by all persons or bodies acting in a judicial capacity under this Act. So, this principle says when an inquiry is going before the board, all the principles of a fair judiciary should be followed. The child should be given right to participation, right to say, right to be heard. So, no bias should be against the child. So, students, with this we have completed the principles of Juvenile Justice Act. As it is clear that the objective of the Juvenile Justice Act 2015 is contained in its principles. We have to maintain all these principles as a thumb rule to bring juvenile justice law in conformity with the Constitution of India and our international commitments. To elaborate further, I would cite an example from a judicial
pronouncement.
In Krishna Bhagwan versus State of Bihar, AIR 1989, court observed that basic approach of this act is curative instead of punitive. So, the judiciary has never hesitated to clear the concept of juvenile justice system, which says it should be reformative and not retributive. For the better implementation of this act, many adjudicating machineries have been established and mentioned inside this act. So, the first machinery about which the act talks about is the juvenile justice boards. Juvenile justice boards are set up in each district under section 4 of this act, and the board shall consist of a metropolitan magistrate or a judicial magistrate of a first class, and beside him or her there shall be 2 other members. Amongst them one has to be a female, and all cases related to the children in conflict with the law are to be first brought before this board. The second structure which is established under this act is Child Welfare Committee. Child Welfare Committee is a statutory body constituted under section 27 of the JJ Act in every district as a competent authority to exercise its power and discharge the duties conferred on such committee in relation to children in need of care and protection. This committee shall consist of 5 members, including a chairperson and 4 other members, one of whom should be a woman and another an expert on the matters concerning children. So, students, a quick recap. Juvenile Justice Board is for the disposal of cases of children in conflict with the law, and Child Welfare Committee is for the adjudication of matters relating to children in need of care and protection. The another structure about which the juvenile justice system talks about is Child Welfare Police Officer. The Juvenile Justice Care and Protection Act calls for designating at least one officer not below the rank of an assistant sub-inspector as Child Welfare Police Officer in every police station to exclusively deal with the children either as victims or perpetrators. Functions of Child Welfare Police Officer: to handle cases of both the children in conflict with the law and in need of care and protection. The Special Juvenile Police Unit is also set up in every district under this Act, and to ensure the effective police interface with children alleged to be in conflict with the law and children in need of care and protection. And this special police unit is headed by an officer not below the rank of a Deputy Superintendent of Police. The sensitization of police in Juvenile Justice Act is very important, as police is the first point of contact when it comes to children in conflict with the law and when it comes to the children in need of care and protection. The other important mechanism about which the juvenile justice system talks about is the child care institutions. Child care institutions means children home, open shelter, observation home, special home, place of safety, specialized adoption agency and a fit facility recognized under this act for providing care and protection to children who are in need of such services. What is an observation home? Herein referred as OH, is a child care facility that is for the temporary reception of a child in conflict with the law pending inquiry. Another institution, a special home. Special home is an institution that is responsible for housing and providing rehabilitative services to children who have been found guilty of crime and ordered by the JJB or the children court to be placed there. The third institution, place of safety. The state government shall set up at least one place of safety in a state, registered to a place person above the age of 18 years or a child in conflict with law who is between the age of 16 to 18 years and is accused of or convicted for committing a heinous offence. So, these were the three institutions for the child in conflict with the law. So, let us see about the institutions which are mentioned for the children in need of care and protection. First such institution is open shelter, means a facility for children established and maintained by the state government, either by itself or through a voluntary organization or NGO, and registered as such for the purpose specified in that section. So, open shelters are like welcome homes to safeguard children from street situations, from abuse. If any child is found living alone on the road, he has to be shifted to the open shelter. Open shelter is open 24/7 and they cannot say no to any child if any stakeholder brings that child for protection to that home. Fit facility and fit person. The committee or board, after due verification, can place a child in their custody for temporary care, protection and treatment as the case may be. Certain situation, if we found a abandoned child who is drug dependent and before institutionalization or rehabilitation reintegration, we have to secure treatment of that child. Since the child is drug dependent, we have to move him in a drug rehab center, and for that purpose Child Welfare Committee after due inquiry can declare that institution as fit institution and can temporarily place that child for the purposes of his treatment in that fit facility. Now, the next important institution under the Juvenile Justice Act is Specialized Adoption Agency. This means an institution established by the state government or by a voluntary organization or a NGO for housing orphans, abandoned and surrendered children placed there by order of the committee for the purposes of adoption. So, dear students, Specialized Adoption Agency is established in a state for the purposes of adoption for the children below the 6 years of age who are found abandoned or surrendered by their parents. They can be put up for adoption and they are temporarily lodged in specialized adoption agencies. Before going further, let us look at some important definitions. Juvenile. Juvenile means a child below the age of 18 years. Board in this act means a juvenile justice board constituted under section 4 of this act. Child friendly means any behavior, conduct, practices, process, attitude, environment or treatment that is humane, considerate and in the best interest of the child. So, let us understand child friendly measures through an example. When we say a child in conflict with the law is brought before the Juvenile Justice Board, the Juvenile Justice Board does not look like a court. The principal magistrate, who is from
judiciary and is a metropolitan magistrate with minimum experience of 3 years,
does not wear a black coat. There is no raised dais in the Juvenile Justice Board. The measures of the JJB is to make the child comfortable, and all these steps ensured by this act are the child friendly measures. Committee. Committee means Child Welfare Committee constituted under section 27 of this act. So, District Child Protection Unit, which is the focal and the most important unit of this act. District Child Protection Unit established by the state government under section 106, which is the focal point to ensure the implementation of this act and other child protection measures in the district. So, students, in this lecture, we have studied that JJ Act provides huge ecosystem both for children in need of care and protection and children in conflict with the law. We have also understood the principles of this act, which are the backbone of efficient juvenile justice system, and we also had a brief idea about the various structures established under this act. Summing up, we can say efficient implementation of Juvenile Justice Act is cornerstone of a well-developed judicial system, and a nation that cares for its children provides for an efficient juvenile justice system mechanism. Summing up, we can say efficient implementation of Juvenile Justice Act is a cornerstone of a well-developed judicial system, and a nation that cares for its children is duty bound to protect the interest of his or her children. So, India is a populated country with a huge number of population of children. We see a growing rise of children engaging in delinquent activities, and we have seen the children in need of care and protection. The cases of both the kind of children are rising high in today's scenario. So, as a stakeholders, be it child welfare committees, be it juvenile justice boards, be it the police officers, be it the in charge of the institutions, be it a common man, be it an NGO, we all are duty bound to ensure the best interest of the children. We cannot grow further leaving our children behind. So, to develop as a nation, to develop as a human being, we need to look into well-being of our children, as our children deserve second chance. All the child in conflict with the law deserves a second chance. Many a times they commit crime when they have no idea or about the consequences of their actions, and sometimes they commit crime just because out of curiosity, peer pressure, or the lack of knowledge. So, as in our home, we give our children a second chance. All the children falling in the net of the juvenile justice systems deserves a second chance. India is a country of traditions, India is a country of value, humanity. No country can grow by leaving his children behind. So, being a responsible citizen, being a responsible student, we should come forward and make sure that every child in our country, in our vicinity, in our neighborhood, in our school, in our college is free from abuse. If child is in need of care and protection, we must come forward and should offer help to such child. And when we are working with such children, we must ensure that the principle of best interest should be followed. Many a times children don't want to go back to their families, they want to stay with CCIs because in many cases the perpetrators of the crime are in their families only. So, before moving in any case, we must understand the case history. We must ensure that the counseling of the child is done we must be sensitized to look into each child as our own child. So, with this, I conclude my lecture on the history and evolution of Juvenile Justice Act, which is the foundation of any civilized society. Thank you.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I'm interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP, you have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with a 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So, the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data, so I will be doing it according to age, by gender and by your weight. So, apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So, for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So data was converted and provided to the users, that is us, from the UK Data Health Survey. So the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So, if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a woman's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now after this, we went in for a policy implication, and in the policy implication we tried to find 2 policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices because it has a impact in reducing your probability of getting high cholesterol. and dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators, and it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day, but fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.